Okay. I think I've been able to put it in portrait mode on Instagram. Okay. Can you guys see me in the right orientation? What's going on? Am I turned upside down? Uh, okay, I think I have to do it this way. Hi guys, hi Instagrammers. I hope you're doing great. I was trying to put this in the portrait mode on Instagram, but that didn't work. Hello, beautiful people. I hope you guys are doing wonderful. I am here, quick live. Today we're going to be discussing a very interesting update in U.S. immigration law. I've actually been sitting here at my office waiting for some people to come and do some installs in the office, but they still haven't showed up. They were supposed to come between 3 and 5 p.m. It's already 4 p.m. So I decided to, come on here. So hopefully they won't interrupt while I'm in the middle of this. So if you are applying for a green card, there is a new form that you need to fill out to submit. Okay. There's a new form that you guys would have to fill out to submit. I hope you guys can see me on LinkedIn, Facebook, YouTube, and Twitter. If you guys can see me, please drop the US flag. If you can hear me, drop the US flag. If you can both see and hear me, drop 2 US flags, okay, as the emoji in the comment section. And then let's continue. Let me know you guys can see me, you can hear me. Okay, I'll keep going until I get the alert not to that you guys cannot hear me. So we're live on TikTok and all the other social media platforms. Thank you. I see the emojis, the US flags coming in. So if you are applying for a green card, there is some latest news that you have to know. Thank you, Instagrammers. So normally, if you are inside the United States and you're applying for a green card, you need to do that adjustment of status process. And the form just changed. The form just changed. So each US immigration form has an edition and an expiry date. The current edition, I believe, yes, the current edition is, to apply for a green card, you need to fill out the July 15, 2022 edition. That's the current I-485 edition. That's the form you use when you're trying to apply for a green card. Now, okay, I see the emojis coming in on Instagram. Thank you, Instagrammers, and on TikTok as well. I see the US flag. Okay, that means you can hear me, you can see me. Thank you, guys. Now, just a few days ago, USCIS, that's United States Citizenship and Immigration Services, announced that from December 23rd, 2022, you must use the latest version of the form I-485. Okay, so if you're going to be filing your green card application after next week, well, this Friday actually, you're going to be filing your green card application after this Friday. Make sure you're using the latest version of the form I-485 and not the previous, not the current version. Between now and Friday, if you file, make sure you're using the old version, which is the July 15, 2022 version. Okay. If you're going to be be filing after this Friday, which is December 23rd, 2022, make sure that you use the December 23rd, 2022 edition of the form. And this is because of, some public charge rule updates. Once, the public charge rule has been a long-standing part of U.S. immigration laws, where if you are coming into you're going to be applying for a green card in the U.S. and they find that DHS, Department of Homeland Securities, they find that you're going to be primarily depending on government to live, for aid or benefits, then they will deny you a green card, because everybody wants, even in a relationship, right? If you are applying for a relationship to get into a relationship with a man or a woman, and they find that you're going to be depending on them to eat your breakfast, your lunch, your supper, they are most likely to they are going to deny your application. They will not get into a relationship with you, because nobody wants to be in a relationship with a leech. Life is all about giving and taking. It's not all about taking, taking, taking. So the U.S. immigration system has a similar setup. If you're going to become a green card holder, and all you want to do is take from the U.S. government, they'll deny your application. They want people who are also going to contribute to the U.S. government and not be a burden on the U.S. taxpayer. Okay, so when so we the rule has been part of U.S. immigration laws that we don't want leeches. The U.S. government does not want leeches. So since it's been in U.S. immigration laws that if you're going to become a public charge, no green card for you. So we had the 1999 public charge rule. President Trump came and he broadened the definition of who a public charge was. And he broadened it too wide, it was too wide. And so there was a lot of complaints. The original definition was that if you're going to be taking non-cash benefits, then that would not be part of the public charge rule. But President Trump ex-President Trump, and said that, okay, even benefits like Medicaid, which were not public cash assistance, would count towards the public charge rule. And so if you took those type of benefits, then you could not get a green card. And then President Biden came and rescinded that policy. So they went back to the 1999 version, or even the 2019. Well, the 2019 was President Trump's version or definition of the public charge rule. So now we're back. They've re-narrowed the public charge rule to only mean what it's supposed to mean. So that's very good news. So I'll be sharing my screen with the people on Facebook and LinkedIn and YouTube. So hold on, guys. Let me share this with you. Is it this one? Yes, I think it's this one. Okay. Okay, there you go. We have it right there. So let me open up my screen. For some reason, I cannot even see my screen myself. This is a nightmare. Okay, let's continue. So according to... No, I still cannot see this. Let me take this off. Let me see if I can... Let me take this off, and then we'll probably do without. Guys, this will be a quick live. Please join us and stick with us, okay? Let me see if I should rather share this one. Okay, let me share this screen instead. This one. I hope you're all doing great and feeling the Christmas season. Today has been a very hectic day for me, so I'm trying to recover from the weekend. It's been very, very hectic. So please bear with me if I'm not bubbly or excited. Okay, I think I found it. I found this one I wanted to share. So let's get into it. Okay. Okay, well, I think I'm still sharing. I'm so sorry, guys. I'm just all over the place. Let me just stop sharing it, and then let me go into this right here. Okay, so as I mentioned to you guys, the rule has changed. So let's talk a little bit more about what the public charge rule is. So please bear in mind, if you think you're going to be filing your application and U.S.A, it should be more, if it's postmarked December 23rd and it's the old edition, it will be rejected. So make sure that they receive your application before Friday if you're using the old version of the form. If you're using the new if you're going to be using the new version, of course, I don't think it's been released yet because we're still using the old version. After Friday, that will be released, and so you can use that and submit. Okay, so so let's talk a little bit more about what is the new public charge rule. So B Nikwe says, take it easy, go B. Thank you. Thank you. So according to the Immigration Nationality Act section 212A4A, who is a non-citizen? So first of all, a non-citizen was the rule, the public charge rule. A non-citizen who is likely at any time to become a public charge is simply inadmissible. Inadmissible means you cannot get a green card. Um, you cannot get a green card, right? Or you cannot get a visa to come to the US. So it states that at a minimum, adjudicators will usually consider a totality of the circumstances. They look at your age, your health, your family status, assets, resources, financial resources, education, and skills. And if you're likely to become a public charge, it's adhered to you. You're not going to get an immigrant visa. This concerns usually immigrant visas. And of course, there are always exceptions. There are some people that, don't have to show that they're, the public charge rule does not apply to everyone. Okay, so some VAWA applicants and some other types of people who are applying for green cards, the public charge rule does not apply to them. Okay, let me see. Okay, so who is likely to become a public charge? An applicant is a public charge only when they're likely at any time to become primarily dependent on the government for subsistence or for long-term institutionalized care at the government's expense. So if you're going to be institutionalized in some type of home for a very long time at the government's expense, then you are likely to become a public charge. Okay, so primarily dependent connotes significant reliance on the government for support. And it means something more than dependent that is merely transient or supplementary. Okay, all right. So that's the kind of the definition of what this public charge rule entails. Now I'm trying to look for. Okay. So what are the benefits that may be considered under the final rule? The types of benefits. Okay. So we'll take a look at a few things. The final rule's definition of the benefits that would be considered under the totality of circumstances test clarifies that there must be benefits actually received by the non-citizen applicant. Okay. So you should actually receive it. The final rule also defines public cash assistance for income maintenance to include only SSI, supplemental security income, cash assistance for income maintenance under the TANF program. I don't want to read all of this. And then it defines what long-term institutionalization at government expense means. Okay, so I think we'll go into the public charge rule much later. I've done a number of videos, discussing what the public charge rule is into detail. But essentially today, I just wanted you guys to know that there has been an update on the definition of who a public charge or what's the public charge rule of the US entails. And that has necessitated a new form, for green card applicants. They have actually re-narrowed the definition of what a public charge or who a public charge is. And now it does not even apply to non-immigrant applications, non-immigrant visa applications. It just applies to immigrant visa applications. And even then, it's for certain types of, most types of applications. If you are exempt, of course, you use the I-864W. If you are subject to the public charge, in addition to the new I-485, you will be filling out the I-864, which is the affidavit of support. Okay. So I think I'll do a video later discussing more, what the new rule entails, and we could probably go more into that. Let me read some comments from Facebook. And if you guys have questions, drop them. I'll try to answer them. Emmanuel Kwisia Akpai says, hi, sis, how's the process? Everything is fine. What do you mean the process? Is there a specific process you're asking about? Cristiano Bing has dropped flags. I don't know which flag, which country flag that is. So Konta Toby says, so if I'm on Facebook, he says, so if I'm a graduate, if I'm a degree holder and want to and fit to work to cater for myself without depending on the government for support, how do I start with my visa process into the US if I'm in Ghana? That's a very broad question that talks more about the eligibility in terms of a green card applying for, an immigrant visa, whether you're eligible for an immigrant visa or not. So please contact us and we can talk about that some more. Okay, so let me take some questions from Instagram. Eric Eric Abayate 7 says, please, when I want to work in the USA, how can I get the chance or the company that I can work with? Just like a regular, you're applying for jobs. You apply, and if they like your skills, then they'll take you on. And if they want to file a green card, an employment-based green card for you, they can, you know, help you with that. They can fill a green card application for you, even if you're in Ghana. Mr. Evans says, does misrepresented material willfully means ban when you're applying? Yes, that means a ban. That's a permanent ban. Misrepresentation is a ban. So you are going to be permanently banned from entering the US. So you will need to file a waiver to be forgiven for whatever you misrepresented to them. Please, which year will the American Visa Lottery be open again? That's Quinsta 88. It will be open next year, I believe. We just completed, no, was it October, November for the DV 2024. So DV 2025 will be next year, October, early October. So that's when you can probably so Delord is my helper says, is employment-based green card the same as the H-1B? So H-1B is a type of employment-based. There are several employment-based green cards. EB1, EB2, EB3, EB1, EB2, EB3. Those are even the immigrant types of employment-based green cards. But the H-1B is part of, it's also a type of employment-based green card, pretty much. Okay, so let me see. There's some comments on Facebook as well. James Colley Hansen says, hi, my dad filed I-130, but unfortunately the DNA didn't match. Oh, surprise. I have been accepted at the University of Dallas. Can I go ahead to apply for F1 visa? And is it likely to be rejected for the student visa? That depends. I cannot tell now. Why didn't it match? Was there some misrepresentation? So it depends. What did they give you at the end of the process? Did they issue you with a paper marking the grounds of why you were rejected? Was your dad sent a notice of intent to revoke your approved I-130? What were the contents? What was the content of that letter from USCIS? And then we can know whether you have any type of issue that you need to rectify before applying for your F1 visa. Because even if you have issues, once you apply for an immigrant visa and you have issues, it will roll over to your non-immigrant type of visa. F1 is a non-immigrant type of visa, so it can still affect if you're inadmissible. Then you are totally inadmissible. It doesn't matter whether for it depends on the ground of inadmissibility, but generally things like misrepresentation, fraud, they cut across both immigrant and non-immigrant visas. Okay, so on TikTok, Nani Portia says, are you open for new clients, please? Certainly we are. Give us a call, 8027800564. On TikTok, you can see our information in your bio, or AKPOKU Law, akpokulaw.com, and drop us a message. Yes, and if you haven't followed us, don't forget to follow, like, subscribe, share this video with your friends and loved ones. Roger says, Bentley Williams says, I'm an European passport holder in the USA for visit. How do I get to stay permanent? How do I get to stay permit to work and live here permanently? European passport holder, which country? You don't like Europe? Oh my gosh. It's interesting that I talk to people from all around the world, people from Canada, France, Sweden, Australia, all these countries, and they're like, look, well, some of them want to come to the US. The ones I talk to, they're like, did you come on an ESTA? I mean, you have to contact an immigration attorney and then see what your options are. Oh, in Belgium, interesting. Okay, Belgium passport holder. You don't like Belgium? Not nice. Is it too? I like Europe a lot. It's a very lovely place. Very lovely. Okay. Okay. Yes, you can contact us and then we can review what your options are. Okay, guys. I am Charles Mensah is asking, please, do you organize mock for interview? We do, certainly. We can help you with that if you're going to be appearing before a consular officer and you need help with preparing for your interview. We can certainly help you with that. Please, what can be done when being accused of overstaying? ICA surprise party plug. It depends. We need to verify your I-94 digital and what's in your passport, reconcile them. If there's an issue, we work on those things as well with CBP. That's a different federal agency that resolves, if you're being accused of overstaying and it's not true, we can help you. We can certainly help you. Call us and we'll show you, we'll go through everything with you and assist you with that issue. Okay. Um, all right, guys. Nana Cerebral says, lawyer on TikTok. Lawyer, I've done my biometric for about 5 months, I assume. I didn't hear from USCIS. Please, why? Don't worry. Check your status. It's probably currently being processed, actively being processed. First of all, it depends on the type of application. If it's a marriage base, if it's VAWA, if it's just it depends, and then just look at the service center your application was sent to, look at their processing times, the type of form you filled out, and then that can give you a very rough idea. But some cases take a long time, 36 months, 2 years, 1 year. So it's not too unusual, 5 months that you're waiting. Get Nailed Ghana says, does your outfit help facilitate student visas as well? Yes, we do. On Instagram. Please, number to call. It's right on our bio. Right on our bio, 802-780-0564. Please check on our bio and you should find it. Okay, so on Facebook, we have some question. Henry Duname says, please, what's the processing time for K1 from Ghana? So the K1, it's taking a while. Before COVID, it was very fast. That's why people preferred it to the marriage-based green card. Now, post-COVID, it's almost the same time as marriage-based green card. So if you did the USCI, from the USCI's level, maybe a year, maybe less, maybe more. And then once it's forwarded to NVC, it takes a while to even get them to schedule an interview. Maybe a year, adult, so maybe 2 years in all, maybe less, maybe more. The truth of the matter is that some people get lucky, it gets processed very fast, some people don't. And in order you want to facilitate the process. So you want to make sure you make as few mistakes as possible. You don't even make mistakes, try not to do it yourself. This morning, I actually had a consult with someone, and it's very common. I've seen a question on Facebook and I'll answer that, talking about a consult I had this morning, and you guys will understand this better. Daniel says, Daniel Boating, the petition you have filed does not allow for derivative status for family members. This means that any spouse, unmarried child under 21 or parent will require his or her own petition to immigrate. Daniel Boating says, I had this for my mom. He's on Facebook. So yes, that's exactly right. This was one of the consults I had this morning. Contact us, we can help you. Most likely the petitioner of this application is a U.S. citizen. If you're a U.S. citizen filing for an immediate relative, that means a parent, a child under 21, or a spouse, then you cannot have a derivative on that application. Each of them, so let's say you're a U.S. citizen man. Let's say you're 30 years old and you're filing for your spouse who's based in Ghana, and your spouse has a child. You cannot add that child on the petition because the spouse is an immediate relative. The child will need his own I-130 petition, his own family relative petition, and the spouse will also need his own petition. So please don't waste time doing some of these things. You might not know about it until. So the person I had a consult with, they went, the process, the first part, they went all the way, about a year ago or a year and a half ago, I can't remember. And her husband filed for her and that child and added the child as a derivative, even though the petitioner was a US citizen. They went all the way to Ghana. The case went to Ghana. They went for the interview only for the child to be not issued a visa because the wrong thing had been filed for the child. And this was a little baby. Mother had to leave the child to come to the US. And they now had to start the process all over for the child. And, it's just a waste of time. You're trying to save money, but in the end, the family unity is more important, so you cannot have a derivative in an immediate relative petition. Will this affect her processing because all documents have been accepted? No, it won't accept her processing, your mom's processing, but the person you were trying to file as a derivative has to start all over again. So, yeah. So Henry Dunami says, so you meant filing married is faster than fiancé, rather, please? No, I didn't say that. It just really depends. It's the same time. I would say the same time frame. They're taking before COVID, fiancé petitions, K1s were really fast. The first part could take less than 6 months or even 6 months. Now, if your case K1 is taking 6 months, that's because you probably filed an expedited case or something, but it's currently taking quite a long time. Both cases are taking an equal amount of time to process. Okay, guys, I hope this live has been helpful to you all. Please don't forget to like our page, subscribe on YouTube, comment, share, follow. Okay. And I'll see you all in the next video. Please take care and have a wonderful night. Bye. Thanks, guys, for joining. Bye.